Good afternoon, everyone, and welcome to today's webinar, which was actually the final one that I'm hosting for 2025. It's now been the fifth year that I've been hosting these sessions that sort of bring insights and different experts in this format to share with you. So appreciate those who are, if whether you're joining for the first time or those who've been joining when I started these in 2020.
All opinions and views expressed by the speakers are not representative of views and opinions of RBC Dominion Securities Inc. All information and opinions provided in this video are in good faith, but without legal responsibility.
As an advisor that's based in Toronto, which is one of the most diverse cities, the topic for today is one which, on the surface, it may seem to apply just to a small segment of the population. However, when you sort of look at the data, which highlights that, most newcomers to Canada end up in Ontario and specifically Toronto or the Greater Toronto area, then it makes the segment of the population who are sort of global citizens, a bit larger. So I'm going to share with you the agenda for today. And there we go. So we've got two persons that are going to be on the panel. We've got Stephanie Batista, who is a colleague of mine with RBC Royal Trust. She is a lawyer by profession and supports us in terms of as a will and estate advisor. And we also have Steve Levy, who's a lawyer. He's got a practice with offices in Montreal, Toronto, and also in the US, which sort of gives him a unique perspective as it relates to supporting clients across the border. And then we'll definitely have we'll be going over just a bit of a case study just to sort of have him highlight certain things, considerations that are important as it relates to, as an example, for the case study. And we'll make sure we leave time for Q&A. That's an opportunity for you to pose questions to any of the panelists. So again, do want to thank both of our panelists for taking time out of their busy schedule, especially being lawyers. So I always really appreciate your time. Your time is valuable. And this is actually the second time I'm having Steve on our webinar. We had done one a few years prior around retirement in the US. So he's got a number of sort of areas of expertise up his sleeve. For anyone that's joining for the first time, my name is Orlando Lopez. I'm an investment advisor at RBC Dominion Securities. Been in the industry going on over 14 years as an advisor, a bit more than that in the finance industry. And in my role and just in my experience, I've always sort of used my knowledge to share in different mediums. So I've done work on radio, I've been interviewed on BNN, sort of written articles for magazines, and this is just another platform that I use to sort of share the information that I think is valuable to clients or the wider community. Outside of my work here, kept busy with two young ones, a son and a daughter. Actually, today was holiday sort of party, sort of concert. So I was at that this morning before coming into the office. And again, these are some of the things that I'm very passionate about sharing my knowledge with the community. So as I usually do, for me, when individuals sort of join these webinars, to make it really valuable for you, it's sort of helpful to kind of get a sense of who's joining. So I typically do that with a little bit of a poll. So I'm just going to share on the screen the QR code for a Slido poll. You could also just go to the website slido.com and input that number 1712954. And let me just sort of pull up there we go. Okay, wonderful. So I'm going to move to the first question. So I'm just having to look away on the other screen here. So just out of curiosity, we're talking about global citizens. Are you still living in the city you were born? Let's give folks time, and you can still see it on the left. Um, so far, no one is in the city in which they were born. Right. And the next question, how about the same country? So are you still living in the same country that you were born? We've got 67, 33, 50-50 split. Okay. Nice even 50-50 until now. Next question. Does, or, if your parents are no longer with us, did your parents, you know, are you living in the same country as your parents? Or are your parents living in a totally different country um, from you? So we've got, okay, so family across, especially close family, not within the same geographic region. Interesting. And final one, do you consider yourself to be a global citizen? Hmm. Okay. 80% said no. Okay. Let me go back to, all right, there we go. Um, Appreciate you sort of participating in that. And just in the vein of, um, you know, global citizens, global reach, I think it's fitting for me to also give a bit of a sense and an insight into the global footprint that RBC has, because it's something that allows us, it allows me to help clients navigate some of the nuances that might present itself around their situations and scenarios. And I mentioned earlier, my day started at sort of a school concert for my kids. And on my way in, before I got to the office, I was on a call with a colleague in the Hong Kong office, 13-hour difference. So this was nighttime for him, just actually talking about how to support a client that is sort of relocated to Shanghai. So again, RBC's reach, for some who may not have known, might be known that we've got a presence in the United States, just across the border. In the United Kingdom, RBC has a wealth management operation called RBC Brewin Dolphin. That was an acquisition that RBC made a few years ago. That's also present in Ireland and the Channel Islands. I mentioned Hong Kong earlier, so Hong Kong and Singapore, that's part of our RBC Wealth Management Asia. And then RBC Caribbean is located in a few countries such as Aruba, Bahamas, Barbados, Cayman, Trinidad and Turks and Caicos. And again, just to sort of give a sense of the global reach that is sometimes not as obvious. And the reason why I say it's not always as obvious um, is, and I'm just sort of sharing a few things here. RBC's operations in the US is with City National. So in the top left, you're sort of seeing City National, but it's a very small font that it says an RBC company. You'll also see another one that's kind of interesting. I discovered this very recently, a firm called Wise, West Indian Stock Exchange based in Trinidad, and in the small fund, an RBC company. We're actually in touch with them in trying to help somebody navigate a particular situation, a particular complexity around share certificates for somebody who resides in Trinidad, but also has a Canadian sort of connection. So again, just sort of highlighting that as the world sort of becomes smaller, as people travel more and more across borders, and life sort of is no longer confined to a small geographic sort of region, um, lives become more complicated, and estates become more complicated, which is sort of what we're going to be talking about. And that sort of, is a perfect time for me to sort of shift as it relates to when it comes to one's estate. um, Beyond, along with the planning, there's also something that we, in my role, that we're kind of keen on looking at, is we're also trying to help individuals identify ahead of time any potential future estate shrinkage. So again, I'm highlighting this is something that is sort of, when we utilize one of our many tools, which is sort of helping clients look at their goals, priorities, and solutions. We sort of use the acronym My GPS, my goals, priorities, and solutions. And I'll send information on this after the webinar as well, but I'm zeroing in on that aspect. So there's a couple of things we use that to look at, help people with retirement planning, but also helps to identify any potential shrinkage on the estate. And then we're able to help them sort of, one, find solutions preemptively. So again, estate shrinkage, I'm now going to shift into one, the role at RBC, one of the roles that we were able to sort of play on the estate administration through our entity RBC Royal Trust, which is where Stephanie is that's the area of RBC that she works in. So I'm going to sort of, one, have Stephanie sort of share high level RBC Royal Trust, the estate solutions, and just sort of give some insights. And especially as it relates to, from your experience, Stephanie, I know one of the reasons I was really happy for you to join is your prior experience outside and before RBC, you were also exposed to cross-border estates. So you've got that exposure prior, and also
Mhm.
within your role at RBC. It would be good for you to sort of share some, high level examples, cases, just how you sort of seen the cross border situation play out, and how RBC Royal Trust has been able to help clients with that.
Perfect. Yes. So thank you, Orlando. So just to I know Orlando did a great job introducing me. Thank you for the kind words. But I'm Stephanie Batista. I'm a senior will and estate advisor at Royal Trust, and so part of my job is to help clients find practical solutions for their specific estate plan needs. And this is particularly as it relates to fiduciary services, like an executor, like a trustee, or an attorney for property. And just so people know who Royal Trust is, we're a professional trust company in Canada, and we've been around for over 125 years now. And our goal is, and always has been, to help clients achieve peace of mind now and in the future. And so today I wanted to focus a bit more on one of the ways we do this for clients, and that's through our executor services. And more specifically, where Royal Trust can step in and help in situations where an estate has foreign connections. And although this could be anything like having assets in multiple jurisdictions, or maybe having beneficiaries who are non-residents as some example, I think today the focus is, for me, is a little bit more on what happens if you have named a non-resident as your executor. So I think, Orlando, with the polls that you had earlier today, it's interesting, but quite frankly, not surprising. I think we see this more and more, that, people just have connections to multiple jurisdictions. And sometimes they might be here in Ontario, but their loved ones, their most trusted people, might be outside of Ontario. And so you might name, your brother as executor, but your brother lives in the US, or your brother lives in Europe. And so there's some challenges there that I'm going to kind of highlight a little bit more today. And just for those who might not be familiar with the role, an executor is an individual or an institution who is appointed in a will, who's responsible for administering the estate in accordance with the final wishes of the deceased, and in keeping with local laws. And I don't know if anyone on the call has been an executor, but even for the simplest of estates, so even estates without any foreign connections, the process to settle an estate can be challenging. It can be very time consuming. There's something like 70, oftentimes over 100 actually, different tasks here in Ontario alone to settle, an easy estate. And that could take a year and a half to 2 years. So when you add in a foreign element to an estate, again, whether that's assets in a different country, or the deceased being having dual citizenship, an executor being a non-resident, this just adds more complexity and more challenges to the estate administration. And although, I don't have time today to go through all of these challenges an executor may face when you're administering an estate with foreign connections, I did want to briefly highlight a couple of the big common issues we see as it relates to having a foreign executor administer an Ontario estate. But a lot of this also applies to if you have an Ontario executor administering a foreign estate or dealing with your foreign assets as well. So just firstly, one big issue off the bat is whether or not an executor is even able to act as an executor in a certain jurisdiction. So one thing to keep in mind is that every jurisdiction, so every province, every state, every country, everyone has their own set of estate laws, and they have different requirements for who can serve as a personal representative of the estate. So just as a quick example, in Ontario, if you die without a will, a non-resident individual, even a spouse, even a child, they're not legally able to apply to become an executor here. And even if a non-resident executor is able to act in a foreign jurisdiction, they may actually be required to pay security in that foreign jurisdiction to do so. And that's actually a big issue here in Ontario, and one that if you've done your estate planning, you might have heard of this bonding and what's a bond, what is the requirements. And really, for any executor who does not live in Ontario and who does not reside elsewhere in Canada or in another Commonwealth jurisdiction, they are required by law to post a bond with the Ontario court when applying for probate here in Ontario. And the size of the bond can be substantial. I think a lot of people are very surprised to hear it could actually be up to twice the value of the estate assets. And the reason being it's needed to protect the beneficiaries from a non-resident executor taking the estate money and leaving the province. Now, practically speaking, in some cases it can be waived, or at the very least it can be reduced, but it's a court decision whether or not to waive. And you might need beneficiary consent. You might need other parties' consent. And if it can't be waived, well, then the executor, the non-resident executor, is out of luck, and they're just going to have to put it in place. And that can be time consuming. There's going to be added legal fees to that, and all could easily be avoided by just not naming a non-resident executor and dealing with your Ontario assets. There are also some, I would say, non-estate law issues to consider, but there's still legal issues to consider, especially nowadays with when you think of all the anti-money laundering and compliance issues. A lot of third parties are just more cautious with dealing with a non-resident. So as a very common example, we have been finding that it's very difficult for a non-resident executor to open a bank account here. And by here, I don't mean RBC, I mean any financial Canadian institution. All of the Canadian banks, they all have very onerous compliance checks, and this is mainly because of money laundering issues. They're just a lot more risk averse these days because there's less recourse in cases of fraud or mistake. And so a non-resident executor sometimes finds themselves stuck at the very beginning of the estate administration because they can't do the most simple of the tasks, which is open an estate bank account here in Ontario. As well, there are security law issues. So, and Orlando, I'm sure, could speak a little bit more about this, but investment advisors in Canada are not able to accept instructions from a non-resident person. So a common example we see is you have your child who goes to school in the US, and then they start working in the US, and then they decide to stay in the US. But the problem is you've named them the executor of your will. And so what happens when you pass away, your US child, who is now the executor, is not able to provide any instructions to the investment advisor about the ongoing management of the estate investments, because the advisor here, they're not licensed to provide investment advice to US residents, and they may not be able to accept any instructions from the US person. And another big problem, which I'm definitely not the right person to dive into this today, but whenever you're dealing with multiple jurisdictions, you're also dealing with multiple tax regimes. So there's always going to be issues for an executor to have to navigate the different tax regimes and the different tax systems involved when you're dealing with a multi-jurisdictional estate administration. For example, one thing that sometimes people aren't aware of is that the tax residency of the estate may be determined by the location of the executor. And that usually is not a good outcome. So again, going back to my US child example, if you have a US executor, the Canadian estate might be deemed a US estate, not a Canadian estate. And so what happens there is it could lose out on certain tax credits, or there could be an increase in certain withholding taxes. And there's definitely additional reporting requirements. So the US executor might need to file an FBAR, an information return with the Department of Treasury. So really, this is by no means an extensive list of all the tax issues, but I think that the takeaway I'm trying to hammer home is that, you know, you add in multi-jurisdictional estate administration, you have to add in all the different tax regimes and how they interact, and it's just more work, more complication for the executor.
And Stephanie, so even in cases where it's not multi-jurisdictional, there are times where royal trust is a solution just based on the individual or that family member might be trusted, but might not have the prior experience in dealing with an estate, all the work that's required,
Of course.
or even the time. So there's now
Yeah.
this other layer that, again, people's life might change. So maybe the child was living in, in the same city and then move, the updating of that will and sort of determining, okay, I need to sort of change the executor as a result of that relocation.
Yeah, definitely. And I think that it kind of segues into some of the next points I'm going to make. But I think the idea, the big takeaway here is if you have a connection to another jurisdiction, and again, that could be your executor lives somewhere else. It could be that you have assets somewhere else. It could be a beneficiary somewhere else. I think the main takeaway here is that that's going to add complexity to your estate. And that's when you're going to need to look to potentially other help because going back to the simplest of estates that have 100 tasks and take 2 years, 2 years to administer, there's a lot of people in your life that just might not have the time commitment, the financial acumen to deal with it. And then you're adding on having to deal with different jurisdictions now. So now you're having to deal with lawyers in other countries. You're dealing with potential language barriers too, right? So when you add these complications, that's where a professional trust company like Royal Trust can really step in and help. And how we do that is that we can be named as an executor in your will, so we could take on the tasks right from the start and not even worry your loved ones with it, and not even worry whether or not that your US child can act because they don't need to be involved. Or we also have we have an agency service where a non-resident executor could hire us as agent to help with a lot of the heavy lifting with the estate administration here in Ontario or here in Canada.
Yeah,
Perfect.
no, that's good.
Yeah. Yeah, and the one other point I did want to quickly read it. I mean, I did talk high level about the legal and the tax requirements, but you also have to think logistical problems too. And I know this one's really silly, but I have seen it firsthand. When you don't have an executor here in Ontario, think about time zones, which I know, again, like everyone's like, this is the silliest thing to think, but we're lucky that you can do a lot of things online. You can meet with a lawyer on Zoom, an accountant on WebEx or whatever, but there are different working hours. And not every professional is going to want to schedule a meeting
Mm,
at 8 p.m. because the executor lives in Singapore and is only available lunchtime. And the executor needs to do a lot of tasks involving third parties. They need to be on the phone with CRA, with Service Ontario, with insurance companies. And so you're going to have to start thinking about if they're not in the same time zone, like logistically, that's going to be a bigger headache for your executors. And that's just assuming you can do things on the phone electronically. There are still things that, you still might need to physically be present here in Ontario for, like opening a bank account, or maybe there's a wet signature that's needed. So I always, the legal and the tax issues are big and important, but don't underestimate just even the practical problems and the logistical problems of having a resident outside of Ontario.
yeah, no, appreciate that. And just to kind of shed some clarity, within one of the things that's not within the parameters of RBC Royal Trust is actually preparing a will for an individual. So it's a good sort of segue to kind of one, introduce Steve, and I'm gonna just share up on my screen here, just for Steve to kind of highlight again one of the many scenarios you kind of touched on, just a very basic, right? So if we've got a couple that got married, bought their property in Toronto, but also bought a Florida property, and they've got two children that are residing outside the country. So so Steve, feel free, would love for you to kind of share, one, your experience in general, and then one, you can touch on this case, and also probably even add on to anything that Stephanie had also sort of shared and mentioned.
Well, it's first and foremost a pleasure to be here. Stephanie touched upon so many very, very interesting points when dealing with multiple situs asset or multiple jurisdictions and assets situated in multiple jurisdictions, beneficiaries in multiple jurisdictions, and then executors or personal representatives kind of roaming all over. And obviously, the restrictions are pretty big, and the lack of knowledge in navigating these situations could be one, extremely aggravating for the families or the professionals. Two, it could get very messy. And three, when lawyers speak about messy, they typically means fees, and it could be therefore very expensive. So I think that what Stephanie mentioned is definitely something that people need to keep very close to their vest and remember, because that could get very tricky. Our practice here really hinges on helping Canadians with their cross-border needs. Again, what Stephanie touched upon is you could be a Canadian living here, having no nexus whatsoever to a cross-border country like the US, for instance, where we do a lot of work with. But guess what? Your kids went to school there and never came back, or your kids came to Canada after school but married an American girl, or next thing you know, your grandkids are down in the US and the same scenario repeats itself. So we're basically here to advise Canadians on their personal and their corporate affairs across the border. And, we see all kinds of ranges from, as your example noted, we bought a condo because we're snowbirds and we'd like to spend 3 to 6 months in the US during the winter months. Or guess what? We're doing business. We want to expand our business to the US, and there's intricacies, corporate tax, estate planning, and so forth. Or we're unfortunately seeing a lot of that. A lot of people are wanting to move to the US and pick up their stuff and move to the US because of the economic climate, the political climate on both sides of the border. I don't pick sides, I just do my job, but there's people on both sides of the political spectrum. So our firm basically does all that, and due to the fact that we're able to not only analyze and recommend, but having offices and lawyers on both sides of the border with the US, we're able to implement. So a lot of it is kind of I wouldn't call it a one-stop shop, but it's pretty much centered around the same areas of expertise. Now, if we go back to the example, purely Canadian couple, worked hard all their lives, they have assets in Canada, that typically gets adjusted by their Canadian will. We'll assume they're in Ontario, right? So their Ontario will deal with all of their Canadian assets. But you raise a very good point. Their kids live abroad. Let's assume they live in the US for this scenario. And they also decided to purchase a condo and own it in the US, and it's their secondary home, vacation home. What are we worried about? What are the issues of concern? If we start with the US side of things, of course, owning property in the US comes with a lot of benefits, especially if the clients in this example purchased, let's say, in Florida or in Arizona or in California, where it's sunny 12 months a year and warm 11 and a half months a year. So great for the lifestyle. What are the issues we as practitioners are concerned with? Well, obviously, because we're talking trust in estates and cross-border lifestyle, there's going to be a big concern upon the passing of the owners. What happens when they pass away? Unlike Ontario, where probate is kind of capped to a process, in common law jurisdictions in the US, probate is typically regulated by a statute and a tariff, allowing attorneys to charge a certain amount of fees to settle the estate. Those fees could be pretty big. In Florida, you're looking at 3% of all the assets situated in the state. And that's besides cost and disbursements that could easily take that fee to about 5% of the value. So if somebody bought a property for $300,000 and they pass away and it's worth $600,000, probate would be at $600,000. It's not a tax on the delta, it's a tax, or it's a probate on the overall value of the situated assets in the state of Florida. Now, something very interesting about Florida probate that we don't have in Ontario is that it could take sometimes up to 12 months, between 12 and 24 months before it's completed. And while that's happening, it's completely frozen. The asset is completely frozen. We can't sell it, we can't rent it, we can't refinance it, but the upkeep costs are still ongoing. So we want to pay attention to that, right? The other thing that we are very concerned with is probably more than probate is incapacity. And here's why. In most common law jurisdictions in the world, where husband and wife own property together, they have a right of survivorship. So on first to die, and specifically to US common law jurisdictions, there's always a tendency by the entirety rule that says that where husband and wife own property together, on the passing of the first, the property goes to the surviving spouse, and we only have to worry about probate on second to die. But today, people live longer, the body stays on, but the mind doesn't always follow, unfortunately. And now we have situations where we have incapacity. And the downside to joint tenancy with right of survivorship is that it doesn't capture the incapacity. So you'd have to wait till the person passes to get the rollover, but the incapacity still freezes the estate, still sets all these barriers to the family in order to manage the asset of the incapacitated person. Here again, the procedure is actually tricky because for Canadians, the incapacity needs to be established where they live, where they're domiciled. So incapacity would first need to be established in Ontario. You'd have to go through the whole process of appointing a guardian, and then we'll need to take that process and domesticate it in the US. So double the time, double the fees, and unfortunately what happens a little bit later on is the person passes on. And when they pass away, well, if they're first to pass, we've got that right of survivorship transfer, but if they're second to pass, now we've got probate. So these are all things that are time-consuming, expensive. Stephanie is involved in settlement of estates. She knows how aggravating it is for the families. And then you add everything that there's no closure, you can't really mourn the passing of your loved ones, etc. We definitely want to get closure on this. Here's another interesting fact about probate in the US. In most states, probate is a completely public procedure, meaning that everybody and anybody could search the records and know that XYZ passed away, and they have access to the petitions and they know what assets are there and who the beneficiaries are and so on and so forth. So we definitely want to avoid probate in a foreign jurisdiction. Once we figure the question about probate, the next thing is dealing with the very dreaded concept of US estate taxes. In the US, when people die, there's a US estate tax regime. And there's a lot of unknowns and a lot of uncertainty, a lot of very bad information out there. The reality is US estate taxes are applicable to Canadians who own real estate in the US and pass away, provided that the value of their interest in the US is greater than $60,000. Okay. So once a person passes away with an asset in the US that is worth more than 60,000, he or she, or rather their estate, is subject to filing a US estate tax return. Now, there's two good news with that scenario. The first one is that there would only be tax if the deceased worldwide estate exceeded the US estate tax exemption, which currently sits at $15 million US. And that's thanks to the Canada-US tax treaty. And the other good news is that even if there were tax levied on the estate, they only levy taxes on the US situated assets. So the worldwide is simply a disclosure to see whether we're over or under the exemption. The tax is only on the US situated asset. The downside to the whole thing is one, we're caught in it, and two, it's a value tax. So it doesn't go into US, like Canadian rules, where we first look at how much we paid and how much it's worth at time of death, and then the delta gets taxed. It's rather a value proposition. It's worth 600,000. If you're over the $15 million threshold, that 600,000 will be taxed on the full value up to 40%. So it's important to, if those of you on the webinar or your clients have property in the US, it's good to look at values, do the research, and understand what's going on. Another great thing about the Canada-US tax treaty is that it allows us, where husband and wife own property together, and husband, let's say, passes away, but leaves the property in the US to spouse, to even get what we call a marital credit, doubling up that famous worldwide exemption on assets to practically $30 million. So when you have $30 million and today's exchange rate, it's like, $1 trillion Canadian, right? So when you have that space, US estate tax isn't as relevant as it used to be, but it's still something we got to look at, okay? And the other stuff that we want to make sure is for Canadians that are snowbirds, like in the example, we want to make sure that they have the proper paperwork while they spend the 3, 4, 5, or 6 months in Florida. Example, question, is my Ontario power of attorney valid in the state of Florida? The answer is no. It's an Ontario specific document. Are my healthcare directives in Ontario valid in the state of Florida or California? The answer is no. So what we want to make sure is if clients are going to spend significant amount of time, that they seek advice from proper professionals to draft these documents. Now, a lot of attorneys will tell you we should have a will in Canada, you should have a will in the US. Well, maybe, but the will doesn't avoid probate. So yeah, it might simplify the process, but it doesn't avoid probate. But most of the time, having 2 wills for 2 jurisdictions, when those wills are not done properly, could create more chaos than anything. Because what is the first sentence in every will after the identification of the parties is, I hereby revoke any and all wills executed by me prior to this one. And
so this is the benefit that when you're supporting clients, because you've got offices in the US and here, you can actually help them prepare both wills if they need to do, or if they want to do wills in 2 different jurisdictions.
Correct. We could advise on what is the best way to avoid these issues that we're concerned with. And then if the idea is to do wills, we could make sure that we do proper US situs wills, meaning that we're not revoking anything. Because next thing you know, you got a tiny condo in the grander scheme of things. You got a $600,000 condo in the US, which is your only asset. And if you did your US will subsequent to your Canadian will, where the other big assets are, and you somehow revoke that Canadian will, well, we're back to square one. And, I had an old client, we did his Ontario will, he was divorced, 3 kids, about $50 million worth of assets. A few years after his will was done, he gets married, he goes to Florida, buys a small condo, tells the attorney in the US tells him you should have a will for the condo, does the will, revokes his Ontario will. When he passes away, as you imagine, because we're talking about it, he passed away. His spouse comes to me and says, I'd like you to move the condo to my name. Turns out she was the beneficiary of not only the condo, but the other $50 million. And his kids were disinherited. So little tiny mistakes like that are going to be very, very damaging. I've got no doubt that Stephanie and her group at Royal Trust has the ability to identify these issues. We'll be able to pick up on them very quickly if they get the chance to review stuff while people are alive. And that's the advantage of making sure that there's always contact. Once you've appointed Royal Trust, it's good that you check in at big events with your trust officer or with people from the estate planning at Royal Trust, because they need to know. They need to raise the hand. They need to raise those red flags.
Yeah.
Go ahead.
Sorry, Steve, just really quickly to add into that, like, I think also you're making a good point that at the end of the day, make sure everybody's on the same page. Like, make sure all the professionals that you're involving, like, your planning is not done in a vacuum. It's not done in Ontario and then you wrap it up in a bow and that's done. And then in Florida and you wrap it up a bow. Like, your Florida people should be talking to your Ontario people, who should be talking to your Quebec. Like, everybody needs to be on the same page, because one change in your estate plan could, as Steve, as you pointed out perfectly, could turn, like, unravel the entire estate plan.
We like to advise our people, our clients, our esteemed customers to always check in with us at big life events. Example, of course, the big life events is when there's an incapacity, there's a death, but sometimes there's a second marriage, there's a divorce, kids are getting divorced, there's a big acquisition, there's a Florida condo, there's a sale of a Florida condo. We want to know so that we could raise our hand and say, you know what, by the way, well, if you're going to do this, this is the effects on your Canadian side. So maybe we should do this instead of that. And it typically helps a lot with keeping people out of trouble. Okay. Yeah. So for me, those are the things that kind of come to mind. Now, the fact that the kids are not residing in Canada is definitely a big flag when discussing the Canadian estate. Okay. Here's another thing we see often is that the kids live abroad, Royal Trust is appointed, and for some reason, the parents want to absolutely deal with the Florida condo in their Ontario will. Well, that's great because you only want to have one set of estate planning documents, but here's what you need to understand. Now your Ontario documents need to serve the probate in Florida. So first, you're going to deal with everything in Canada. You're going to go through the probate process. It'll take whatever time it takes. And then you're going to get a probate judgment, and you're going to need to take that and still domesticate that in the state of Florida, where in the US, most jurisdictions would favor some sort of revocable or living trusts to own titles so that you could avoid probate. And the advantages of revocable or living trust, when they're done properly for Canadian with the proper cross-border language and mechanisms, what they do is, even though you've bought for a certain value and it's increased in value and you realize you have probate, or you come to recognize one's mortality. A lot of people think they're never going to die, and then they hit an age and they realize, oh my God, we're going to die one day. And now they start scrambling, putting their estate planning together. So if you've woken up 40 years later and your condo's gone up in value and you realize there's probate, doing a rollover from your names to a cross-border trust or living trust is done on a tax-free basis. It will avoid the probate, it will avoid the incapacity, but it won't interfere with your Ontario assets. That's the fun part. However, if you are going to put a will in place in Ontario and speak in your will about Florida, and then subsequently do a U.S. trust or a cross-border trust, now we're going to have conflicts of private international law. One document says probate, the other one document says no probate. Which one do we use? They are both dealing with the same asset. So these are little red flags for people to know that it's great to speak to your Canadian advisors, it's great to speak to your US advisors, but as Stephanie just mentioned, it's incredible to have the two people talking, but we come as a law firm and we kind of created this new expertise called cross-border where we could talk, and I always laugh when I say it because but we talk from both sides of the mouth. We speak American and Canadian and American in one conversation. So it simplifies things and it keeps us out of trouble with respect to what ifs, right? And then going back with a last point, going back on the example you projected, is that in this exact example, Stephanie is going to need to be a very important player in the estate because the kids are non-residents. In this example, the kids for Ontario are non-residents. So they're going to be subject to the famous withholdings. If they're in the US, they're going to be subject to a massive compliance obligation. And here's one that Stephanie didn't speak about. An estate is typically referred to as a trust in tax world. And if the two kids live in the US, for example, and they're the sole executors of that Canadian estate, well, they're now executors of a foreign trust for US tax purposes. And from Canada's purposes, they're the executors living in the US, and so trustees living in the US. This estate could be construed as a non-resident estate in Canada, not getting the graduated rates estate rules and a bunch of detrimental stuff. So it's very, very important to be linear and make sure everybody speaks to each other. And in a perfect world, when you have a great team like Royal Trust involved in your file, they typically seek out the professionals to handle the different situations. So I think it's great. And with that, I think I want to pass it to you for some Q&A and
we'll do that. And what I'll highlight to everyone before we open up to questions is this is, again, there's no way it's possible for us to touch on all the different jurisdictions in one sitting, but it kind of highlights that even when you're focusing on one other jurisdiction, how the nuances are sort of really particular. If, whichever other country, there's going to be some differences. And what we hope from this is that this will encourage taking some sort of action, because if there's no action taken, then this sitting and your time and you're investing with us this evening would be similar to you just watching a YouTube video and moving on. So we encourage you to reach out and be more than happy to sort of have a conversation, myself and just all the other individuals within my network to sort of help you to sort of take stock. And I'm going to open up for questions.
Yeah, that's a great question. And it technically does, but really there's not a problem. Like the problems that you see aren't so much outside of Canada. Especially just as an example, Ontario and BC are actually very, very much alike in our law. So there's no issue there. It always falls down to, and this is a very lawyer answer, I apologize, but it does depend, and it's always something to at least explore with your lawyer. So even though generally speaking, yes, it would be considered non-resident if you're outside province, practically speaking within Canada, it actually usually is not a problem. But definitely speak to your lawyer about it just to just to make sure. Right. So that's a little outside the estate scope because that would be a third party requirement. But one thing to know is you can do a PO, a power of attorney. Like if you did have a BC resident, excuse me, you can always appoint someone to do it. I don't know, Steve, if you have any familiarity with that, because that's more outside the estate scope, and if it's just a third party requirement that you need to be present to sign a line of credit.
Well,
I haven't dealt with that, to be honest.
Yeah, some jurisdictions are very, very picky. In Quebec, for instance, the obligation is to sign in person before a Quebec notary, although all the forms are signed electronically on a tablet. So, which is weird, right? We go to jurisdictions like Florida, for instance. Most people are going to want to be signing in person, and it's still wet ink signatures. However, they do allow what they call remote online signing or remote online notarization, rather, but the process is third party, and you need a witness that could attest that the people on screen are actually who they say they are. So it gets complicated. And for instance, the state of California would only allow you to sign on US soil. So all kinds of weird stuff. It's jurisdictional and it's a case by case, I'd say, Mavesh.
Yeah, I've come across that where we're helping a client with financing, getting some US financing for a property they already had, getting a line of credit. They needed to drive across the border to sign some of the mortgage documents because they needed to be on soil. So definitely a lot of nuances. But thanks for your question and thanks for joining. I'm looking to see if there's any other hands that are raised. We've still got same amount of folks on and listening, and we've got about 7 minutes before we get to time. I'm just sort of seeing if there's any other. Okay, yes.
US tax rules are very, very different than Canadian tax rules. We're so close and so similar, yet we're so far away. For instance, if the US considers, because the executors are US taxpayers, if the US considers to be a US estate because of mind, body, and controls in the US, then all the assets are subject to taxation in the US. All the assets are subject to compliance obligations and disclosure obligations in the US. You know, they've got the FBAR rules, foreign bank account reporting rules in the US that impose a slew of compliance obligations to Americans who are signatories over bank accounts in Canada. If the estate is comprised of corporations and holding companies, it's going to be devastation because the concept of retained earnings that we have in Canada doesn't exist in the US. So you're constantly pushing dividends out to the US, where in Canada there's no tax. In the US, there's a tax. So it could get very, very messy from a US perspective. And from Canada's perspective, losing the graduated rate on estates for the first 3 years could be devastating from an income tax perspective for the estate. So again, using royal trust, using local agents, using local liquidators when the beneficiaries and best case executors live abroad is a great solution.
And I'm going to take also based on my understanding of the question as well. I think my way I understand the question, I'll repeat it, is where does the tax liability fall? Is it the beneficiaries or would be the estate? Generally, the liability would be the estate needs to pay the taxes owing after the assets are no longer in the hands of that individual, because immediately when they pass, there's no an estate. These assets are within the estate, and there's that transition period before it goes to beneficiaries. If for whatever reason an estate doesn't have the liquidity or is not able to pay taxes, this happens also here in Canada, the CRA may go knocking on the beneficiary's door. Now, how does this sort of play out where the beneficiaries getting assets before the estate is being wound up? This is very common with registered assets like RSPs and TFSAs, because you put a named beneficiary on an RSP, and if it's $1 million in an RSP, it goes directly to the beneficiaries. It bypasses the estate, but that RSP is taxable to the estate. And if, for hypothetical reasons, if there's nothing else, all that individual had on their last day was a large RSP, no real estate, $10 in their bank account, nothing else, then there isn't anything in the estate to pay the taxes that got triggered from the value of the RSP. And in that sort of unique scenario, CRA may go knocking on the beneficiary's door to say, wait a minute, there was taxes that was not paid. So I think that's sort of what I understood from what you were asking, and my assumption, again, I'm not an accountant, so please don't take this as tax advice, but I would not be surprised if that's sort of how it might be also played out in the US in a similar or close enough, because again, there's always these slight nuances, but I wanted to kind of give that example. Stephanie.
Just to add to that, not to add more complication that's needed, because again, I'm not a tax expert, but one thing to note too is, like, we're focusing on US and Canada here, but Canada only has tax treaties with 2 countries, maybe a couple more now, but for sure the US and for France. We don't have tax treaties with any other country. So if we're talking about assets in other jurisdictions outside of these 2 countries, this is why it's important to get the tax advice while you're alive, because some countries actually have laws where it is payable by the beneficiaries and some by the estate, and then you have that conflict of laws issue, where the executor has to figure out who pays what, where to allocate between the assets here in Ontario versus overseas. So that wasn't an answer to your question, but just something to keep in mind is that we focused a lot on the US component of it, but there are people who have assets in other countries and there's no tax treaty with them, and so there definitely could be a conflict, and it's good while you're alive to explore what those conflicts might look like, right, to try to figure them out while you're alive.
Yeah. All right. No, thank you. And I do, again, before we hop off, want to thank both of you, Stephanie and Steve. Thank you very much for your expertise, your knowledge, your experience. You really shared a lot. There's I openly admit to everyone that when I do these sessions, it's not only you, the attendees, that are learning, I'm learning along the way with you. And I, just being a curious mind. So with that, I want to thank you all for joining, and for those who, took time out of their lunch hour, wish you all the best for the rest of the day, and festive holiday season, and Happy New Year when it comes. Feel free. I'm not hard to find, and if it's not something that I'm able to help with, again, happy to sort of connect you with individuals within my network, internal to RBC or external. So with that, I want to bid you all farewell and take care. Thank you, everyone.
Thank you so much.
Okay, bye.